Welcome to the debate. So right now, the federal government is quietly spending millions of dollars to build this massive bureaucratic machine to do something it really hasn't done in over 30 years.
Right, a total freeze for 3 decades.
Exactly. They are finally getting ready to restore the gun rights of convicted felons. We're talking about the upcoming launch of a federal online system which is governed by this specific law, 18 U.S.C. Section 925C.
And just to keep it simple, for decades, people with past felony records have been legally barred from having firearms, even if they serve their time and live peacefully for, years or decades.
Yeah, the law technically said they could apply to get those rights back, but the actual system to do it was completely paralyzed. But now that machinery is finally turning back on. We are witnessing a historic shift.
We definitely are.
And that brings us to the core disagreement we're tackling today, which is all about timing and action. When a system is this close to opening, what exactly should you do? So here is my position. Because the government is actively building this system right now, individuals must take powerful affirmative action today to gather their paperwork using the new eligibility tools.
And my position is that because the final rules aren't published yet and the general public online application isn't actually live, it is completely understandable and frankly advisable to wait rather than risking confusion.
And just to establish where we are getting all this, our discussion today comes directly from recent reports, court filings in the Williams versus Attorney General case, and the newly released 2A rights eligibility tool and the 95C workbook.
Right. We are looking at the actual data and the legal realities on the ground.
I mean, President Trump signed an executive order, the money has been invested, and the government has actually created the specific 2A rights part of the department to handle this.
They have, yeah.
So waiting right now is just a mistake. People need to invest in themselves today. They need to get their historical records together, get organized, and be completely ready for day one when that online system turns on.
I hear you, and I completely recognize the excitement here. But we have to look at how this system was frozen in the first place to understand why caution makes sense. Back in 1992, Congress didn't actually repeal the law. The law, 18 U.S.C. Section 925C, it stayed on the books.
Right. It never went away.
Exactly. Instead, Congress used what's called an appropriations rider. Basically, they just passed the budget rule that said the ATF, the agency handling this, was legally forbidden from spending a single dime to process these applications.
It was a total bureaucratic workaround to freeze a rate.
Yeah, it was. Think of it like a city that builds this massive high-speed subway system, but then the mayor decides to turn off the power grid. The tracks are still there, the trains are sitting in the stations, your right to ride the train exists on paper.
But there's no electricity.
Exactly. No funding, so nothing moves. For over 30 years, this process has been totally shut down in the dark. And right now, sure, the government is starting to flip the breakers back on, but the process is really only informally open for a few people, like those filing lawsuits or asking for pardons. So hesitation is the most logical response until the doors officially open for the general public.
Okay, let's talk about those breakers flipping back on. Because to understand why people should act now, we have to look at the concrete proof that the government is actually giving rights back, right now, as we speak.
Well,
If you see people walking out of a store with groceries, you know the store is open. You don't just stare at the closed sign on the window. And we literally have people walking out with their groceries. In the past year, 32 people have had their gun rights restored.
32 out of millions, though.
True. But look at the trend. 10 of those were restored in 2025, and then Attorney General Pam Bondi restored 22 more in just the first 5 weeks of 2026 alone. These were people with no recent arrests. They proved they were safe and they got their rights back. The proof is there.
I come at it from a different way. Those 32 people, they represent a huge exception, not the rule. The government's own lawyer admitted in federal court that this is an informal, interim process. It is only really working for civil litigants.
Which brings us right to the Williams case.
Exactly, the Williams case. Edward Williams lost his rights over a DUI back in 2005. To get anyone to even look at his application today, he couldn't just, go online and fill out a form. He had to file a federal lawsuit. He had to force the court's hand. Right now, Practically speaking, you have to be in a lawsuit to get their attention.
I agree he had to file a lawsuit, but the lawsuit itself proves my point. During those oral arguments, the government's lawyer, Vivek Suri, explicitly said, the Attorney General is inviting people to apply.
In the background, yes.
Right, they are investigating these in the background. And the most important thing Suri said on the record was, I expect the numbers will rise significantly. The government expects a massive wave. If you wait for the official flood, you are going to drown in the backlog.
I mean, you're interpreting a lawyer's prediction in court as an official call to action. The DOJ is explicitly saying this won't be widely available until a final official procedure is published.
Right, but
If a business says, get in line for our grand opening, but they can't tell you if it opens next week or next year, it makes sense for a consumer to say, I'm going to wait at home until I see a firm date.
I see why you think that. But let me give you a different perspective. Let's look at how the government is preparing mechanically, because the infrastructure is already built. They didn't just write a memo, they created a whole Second Amendment rights section.
They did, yes.
They released the funding. They are actively hiring attorneys right now just to read these applications. When the government hires specialized legal staff, the launch is imminent. The online application could go live on a random Tuesday. You don't wait for the rain to start before you buy an umbrella.
But your argument assumes the application requirements are fixed, and we know exactly what they are.
We do know the basics.
We know the basics, but we don't know the final rules. Look at the Administrative Procedure Act, the APA. On July 18, 2025, the DOJ published proposed rules, and proposed is the key word. The public comment period ended in October, and they received thousands of comments.
Which they're reading right now.
Exactly. They are legally required to review thousands of comments before they publish the final rules. Because we don't know the exact final rules, jumping the gun might mean you do the wrong paperwork. And in a federal bureaucracy, doing the wrong paperwork means your application gets rejected.
Yes, the speed of the bureaucracy is frustrating, but you are kind of overstating the mystery here. The basic requirements are not a mystery. They are set in stone by the law itself. 18 U.S.C. Section 925C.
The statutory baseline, yes.
Right. You have to prove you are no longer a danger to public safety. The final rules might change, like the color of the ink or the PDF format, but proving you've lived a clean, law-abiding life, that's a given. You're going to need your court records. You're going to need character references.
I agree. The core requirement is proving you're safe, but translating that into a rigid federal application is tricky. A misplaced date or using an outdated checklist can get you kicked out of the system. People have been told for 30 years they can't have this. They don't want to dive in blindly and get rejected on a technical trap.
But they don't have to do it blindly. That is exactly why I am making such a powerful affirmative push for the tools that are available right now. We know the basic requirements, so you can prepare today without getting overwhelmed.
Okay, but what specific tools can bypass a pending federal rulemaking process?
They don't bypass the rules, they organize the applicant. First, there's the 2A rights eligibility tool. It takes just a few minutes to use. It checks the key variables, time since the sentence, nature of the offense, all that. And for 9.99 cents, a person gets a personalized results report to download and print.
$9.99.
Exactly. It is a tiny investment to figure out exactly where you stand before you start digging up decades-old paperwork.
I have to question that, though. I mean, we are talking about a complex federal legal process that hasn't existed in 3 decades. Can a $9.99 tool really prepare someone for a DOJ investigation?
Yes, it absolutely can, because its entire purpose is to break down that massive legal complexity into something simple. But that tool is just the first step. I also strongly advocate that people go to LegalGangster.com and get the 925C Made Simple workbook.
The workbook?
Yes, it provides step-by-step, easy instructions. It has checklists and worksheets to start gathering your life history together right now. And the numbers prove it works. Over 3,866 eligibility checks have been completed. Over 1,268 workbooks purchased. And 98% of people found it helpful. 98%!
Okay, but look at how it's marketed. It's written at a 4th grade reading level. Does a 4th grade reading level workbook truly prepare someone for federal attorneys who are aggressively looking for a reason to say no? A simple checklist is great for organizing, your garage, but is it legally robust enough?
Yes, because simplicity is exactly what people need. The 4th grade reading level is a feature, not a flaw. It intentionally cuts through the terrifying legal jargon that keeps people disenfranchised. This information needs to be understood by the people who need it the most.
I understand wanting to make it accessible.
Right, and the federal attorney reviewing the file isn't grading your reading level. They are looking for the supporting documents. The only way an average citizen knows which documents to get is if the instructions are clear. By doing these checklists today, you figure out what court records to request. If you do this now, calmly, you won't be scrambling, stressed, or at the back of the line on the day the website turns on.
I hear your passion for this. And yes, being personally organized is good, but we really can't ignore the DOJ's current posture. The public comment period ended in October, and we are still in the dark on the final rules. I just want people to be safe and protective of their time.
I get that.
It is completely understandable for someone to say, I'm going to wait and keep my 9.99 cents until the government officially turns on the website. When a system has been broken for 30 years, it's a calculated, protective measure to wait for the official open for business sign.
But waiting comes with a huge cost in time. The government lawyers said numbers will rise significantly. If hundreds of thousands of people wait for that sign and they all rush the system on day one, the server will crash. The line will stretch for years.
That is a possibility, yes.
The people who used the eligibility tool, the people who went to legalgangsta.com and worked through the workbook, they will already have their files perfectly organized. They just transfer their info into the portal. They will be at the absolute front of the line. It is the ultimate way to take control of your future.
Well, we are clearly looking at the same landscape and seeing two different paths. I see a foundation that's poured, but the house isn't finished yet. The 30-year wait has caused understandable hesitation, and with the rules still pending, I think waiting is safe. But looking at the bigger picture, I do agree with you that the tide is undeniably turning.
It really is.
The fact that 32 people have navigated this interim process and that the DOJ has a functioning division for this, it shows this is a historic moment. The machinery is finally coming back to life.
It is a historic shift. The system is built, the government is hiring, and the funding is there. We definitely both agree that being informed is way better than being caught off guard. I firmly believe using the eligibility tool and the 925C workbook today is the best way to ensure you aren't left behind.
Right. Preparation is key, even if we disagree on the exact timing of filing.
Exactly. But ultimately, the choice of when to start gathering your paperwork is in your hands. We encourage everyone to explore the tools we discussed, review the materials for yourselves, and decide your own path forward. You know the trains are about to move again. The only question left is, when the doors finally open, will you have your ticket ready?